Your Honor, my name is David Huey. Of course, I represent, her name is now Robin Barajas. She was Robin Barajas. We brought this motion for enforcement. The monthly child support, it was unpaid by the respondent. We brought it for uninsured medical. It was, not paid by the respondent. And a modification, we're seeking to enforce both the modification and the original divorce. The divorce that we're seeking to enforce was granted on December 23 of 2020. And the evidence is going to show that the modification order was signed and entered on April 22nd of 22. We have stipulated to the Attorney General's exhibit, and you're going to see that the Attorney General has used numbers on when they believe the son had graduated from high school and or had dropped out. And that's probably the biggest inaccuracy in their stuff. So the Attorney General is showing a number, and the evidence will show with the true number is you take 550 that started on April 15th of 2022. And then the oldest son turned 18, but was still enrolled all the way through August. The evidence will show August of 2025. If necessary, Judge, he's an adult child, and I have him here at the courthouse to testify to his involvement at that time in schools, because that's the biggest dispute. Is it the evidence will show that it dropped down to $440 a month after that time. So the math is pretty simple. We're going to show you that it's 41 payments of 550, 2 payments of 440, and the arrearage that we seek today on the child support portion is 1,000. Look for that figure, pardon me.
Is it on page 14 of the OAG's record?
No.
Okay.
That's an overage, but it's incorrect because the 440 started too early.
Okay.
The evidence that show. And it's in my order, but it's 1,000 and some change. It's like 1,000. Oh, it's right here, $1,091.76. And that number, Judge, was derived, if you look at what the court order said to pay when he turned 18, graduated from high school. And it stopped in November of 2025 because the youngest child, the evidence will show the youngest child, there was a Rule 11 agreement. And it was supposed to stop at that time. But it's still a pending case, but it's before the court still. We also seek 1,600 and some change uninsured medical that's set out. I think the evidence is going to show that there's a dispute between the two parties as to whether my client ever presented those uninsured medical bills to the father. And that's going to be disputed. We contend that we did. He contend, I believe you're going to see that he'll contend that we did not. So that's child support. The other thing is he never paid. He was ordered to pay. There were attorney's fees of $2,500 stipulated to that we incurred in the modification order related to conservatorship and child support. It was not ordered to be paid as child support. The evidence will show that. But it's never been paid, the interest on it, and we believe that the accurate number is $3,038.71 with interest at this time. Okay, we
As of today?
As of today, the
compounds annually.
it's a prior judge, and so if the court's not going to entertain that as a child support arrearages today, then we would ask that just be made. We're requesting the court find that since it was related to the child support stuff, but it did not order it as child support. And then lastly, we've incurred attorney's fees, Judge. I have estimates on the exhibits. I had to produce exhibits at the pretrial, so I tried to put estimates in. I've since then have had a hearing, got ready for it, and again, this hearing today. I'm going to tell you, the estimates are fairly accurate. It's about 20,000 that she's had to spend, incurred. But what we're asking for today is $15,000 in attorney's fees and costs. And we are asking that the attorney's fees today be awarded as, payable as child support, whatever the court determines that the payment term should be payable as child support, but we would like that included in the arrearages that you find as child support. And, we're gonna ask for a monthly payment of those arrearages. And so, my client would like, is really asking that he be told to do all this stuff by a certain time. Suspend of any finding of, you know, if there's the contempt and everything, and, we really, I think I speak on behalf of my client clearly that the goal is not to put him in jail today. Okay, but the goal is, if he's gonna ignore stuff and continue doing that, we want the ability to come in with an order of confinement. At a later point. That's all we seek today, Judge. Thanks for your time.
Thank you so much, counsel. Attorney Redleaf.
Yes, Your Honor, thank you, please, for it. Taking these issues up sort of in reverse order. On the attorney's fees from the previous order, those were just ordered as attorney's fees. That is a judgment that is not child support. It's not enforceable under the mechanisms of child support. Opposing counsel acknowledged this in his opening statement. My client acknowledges he had this. There was a misunderstanding on his part about what that was. So they're entitled to a judgment on that today, but it's not enforceable by contempt. You cannot be held in contempt for failure to pay contempt. That's the law. We just ask you to uphold the law. Certainly, you're allowed to adjust the interest rate. Certainly, you're allowed to make a monthly payment ruling on that. You know, of course, reduce that amount to an abstract so that they can file liens and they can try to levy anything that they wish to levy. They can go down the enforcement lines for a normal judgment. It's not enforceable via contempt today. And we just ask the judge that you apply the law on that. Now, on the cash medical support with the court, on the cash medical, for the unreimbursed medical expenses, what the order requires is that if a bill is presented within 30 days of treatment where it's being paid, he gets 120 days to pay before he is in arrearage, and it was that money that's from the divorce decree. We believe the evidence will show that the only evidence that he ever received a copy of the bill for the unreimbursed healthcare expense, some orthodontic work, was when he was served with this enforcement motion back in April of 2026. So April 25th on return of service, which has been pre-admitted as one of Mr. Huey's exhibits. 120 days, I did the calculation, from the date of his service is actually August 22nd, 2026, which means he's not behind. It's not an arrearage at this point. It's simply an obligation that has a due date in the future. Once again, he's not in violation of the order. It wouldn't be grounds for a contempt finding or even a finding of arrearage, because again, it's not due until August 22nd, 2026, based on what we believe the evidence will show of when he actually received it. Finally, on the child support amount, this is very clear. You have before you in Exhibit R5, which has been admitted, a payment record from the OAG. It shows you what they received from Mr. Huey and how much they've tracked of his obligation. Now, Mr. Huey's argument is the OAG,
They didn't receive anything.
excuse me, exactly what they received from my client. Okay. Now, what Mr. Huey's argument is that the numbers on the OAG's record are wrong, and he actually owed about $1,000 more than what the OAG thought he owed. What that payment record proves to you, though, is that he paid more than $1,000. Now, we don't believe the OAG's number is wrong. This might be the first court to ever say, actually, it's the OAG's fault. And, the OAG's payment records are not a reliable piece of evidence. But even if you agree with Mr. Huey that the OAG improperly assessed, what that means is that my client owed $1,000 more. My client, what that payment record proves is that he paid $1,000 more. Now, the OAG thought, well, that $1,000 shouldn't go to Mrs. Rojas. It should go back to my client. But that doesn't mean that if that's a mistake, that's the OAG's mistake. That's not my client violating the order. Where was my client's obligation? Pay the OAG. That record proves to you he paid the OAG obligation. By the time it was done, he had overpaid according to the OAG by over $1,000, more than the amount that he says he's short. Did he violate your court order? Did he violate this court's court order? No. He paid the child support amount over the amount, and then even if they were correct in the numbers saying actually it was supposed to be this, then he paid that amount, and he's not in contempt. He didn't violate the order. So that's why we don't understand why we're here, because This matter was filed, as you can see from that payment order, he was in an overage as of November of 2025. This matter was filed in December of 25. My clients had to defend against this. Hired me, I was hired on Wednesday, I did not attend the pre-trial hearing. My client had counsel at the pre-trial hearing that did not show up. Allow him to present your evidence to you. And even under Mr. Huey's own argument, that the OAG made a mistake, my client fulfilled his obligation and cannot be held in contempt. He did what the order told him to do, he did what the OAG told him to do. If there's a problem where it's just like, well, actually, this money that was given back to my client as an overpayment should have gone to her, certainly, that's a distribution problem. That's not an enforcement of child support problem. That's a distribution problem that is the OAG's issue. It's not my client's issue. My client can say, if he received the money, give that to her. But he's not in contempt for court for failing to pay. That payment record proves it. Thank you.
Thank you.
Okay.
Question, we've both of you mentioned the Attorney General. Were they not participating in the hearing?
Don't be wrong.
Okay,
I would like to add, I meant to add in my opening that we are seeking enforcement of the cash medical pay that was paid through the AG.
okay,
And that she didn't receive any of it, and it's like $29.50. And if you look closely at the Attorney General statement, you will see there's a column for child support paid in, and it's like. And I mean, if you take that number and you calculate, like we're saying, 41 payments of $550 plus 2 payments of $440. I think you're gonna see that there's an arrearage of $1,000 that he did not pay. But he's getting credit for the cash medical pay on this document. What you'll see.
And Your Honor, just in response to that, since I wasn't going to read open, you will see it. They assess a cash medical obligation against him, and they collect cash medical from my client, and they assess it in both columns. They assess money against his child support obligation. That's the second column from the left. And then they also assess the medical support obligation, and they assess his payments against that obligation as well, and they track both all the way to the end. So, like, as this admitted evidence from the OAG, this is the OAG's record. The undisputed evidence in front of you is that he paid all of the obligations, and then the OAG thought he paid more than $1,000 than necessary. Their argument in front of you today is actually the OAG number was wrong, he owed $1,000 more. This proves that he paid them. Now, if the OAG, instead of sending a check to my client, should have sent it to their client, sure, we can entertain that. But what the question before you today is, did he fulfill his court-ordered child support obligation, which was to send the OAG the amount of money that he sent, which he did. This record proves it. Thank you.
thank you. Attorney Huey, you may call your first witness.
Thank you. I'm gonna call the petitioner, Ms. Barajas, to the stand.
Ms. Barajas, just pull the microphone close to your mouth. Attorney Huey, you have 8 minutes and 20 seconds left. Attorney Redleaf, you have 9 minutes and 16 seconds left.
So we're limited to 30 minutes today.
Yeah, it's 15 minutes aside.
For 10, okay.
Yes,
Okay.
that's the reason you all pre-admit, and then we stipulate to your exhibits.
Stage full name.
Robin Iris Barajas.
Hold on 1 second. Is that microphone on?
You prepared a motion, you prepared your summary of requested relief as M1, is that right? Yes, you're allowed to, is it M1?
Yes,
Okay, the monthly, what you're altering today based on the openings and what we received from the Attorney General, you're actually asking for $1,091.76 monthly child support, is that right?
yes,
And then cash medical support, 2,900, and the rest is what your, the attorney fee arrearage, is that right?
yes,
Okay, tell the court you have 2 children that were entitled to support on the orders that we're seeking to enforce.
yes,
And you're seeking to enforce the divorce decree, like you said, in opening of December 23rd, 2020.
yes,
And also the modification order of 415 of 2022.
yes,
Okay, child support was not ordered in the divorce decree, is that correct?
that's correct,
And child support was ordered in the modification order.
yes,
Did the divorce decree that was granted, did it order cash medical support?
that is divorced.
Yes.
did not have cash, or cash medical, yes.
Of how much per month?
I believe it was
$50?
$50.
Okay, and it began January 1 of 21?
Yes,
Okay, did you receive any of those payments?
No.
And have you determined how much you were owed on that?
yes.
How much?
Roughly 2,900.
Okay, and, were you awarded, in the modification, were you awarded child support?
Yes,
And was it $550 when 2 children were there?
yes,
And was it $440 that it reduced to $440?
yes.
Okay, your oldest son, the son is the older child, correct? When did he turn 18?
He turned 18 November 25th, 2024.
And when was the last day that he was enrolled in school roughly?
Roughly, last day was August 11th, 2025.
Okay, so he was enrolled in school in August.
Yes,
Was the child support supposed to continue $550 then until August of 2025?
yes, that's what I believe until he graduated.
Okay, so that would have been 41 payments if you do the math. Okay, and that would be, and you did the calculations with me. It was 41 times 550, which is 22,550. Is that correct? Okay. And then there were 2 additional payments of 440. Is that correct?
Correct.
And that was totaling 880.
Yes,
And the total that he was ordered to pay for child support was 23,430. Is that correct?
correct.
Okay, but that does not include the 2,900, does it?
No.
So the, if you look at the exhibit that was admitted, which she does not have a copy of an approach witness, Your Honor.
Yes.
Okay. If you look at the Attorney General's exhibit on the line for the child support, the amount due and applied, the amount applied is how much total?
22, 338, 24 cents.
Okay, so that's less, that's $1,000 and 91, 1,091 short, is that correct?
It says right here under balance, 1,122.61 cents.
No, that's not correct.
Okay.
That is not. The calculation, okay, 20,
From what you had earlier, the calculation.
Objection on leading.
okay,
What was it?
Leading, she.
Sustained.
okay. You stated earlier that the full amount that he was ordered to pay was 23,430 in child support.
Yes.
correct? Okay. And the amount shown in child support applied, only the child support portion, how much is it?
Oh, okay, so the amount applied was 22,338.24.
And then that difference was the 1,000 that both lawyers represent.
$1,090 and change.
Okay, thank you. Now, in addition, was he ordered to pay half of the uninsured medical expenses?
Yes,
Did you provide him copies of the medical expenses you're here for the court on?
yes, I did.
Okay, how did you provide the copies?
There were physical copies in the beginning when he lived at his parents' house at 212 Park Avenue on the Mesquite. And then whenever I couldn't get a hold of him, I would just text him a picture of the actual invoice after I made payments. So it would tell him the balance that was left, the amount that was paid and everything. So he had everything from the beginning all the way through.
Okay, and I'm gonna ask you to look at exhibit M8, it's on date stamp 142,
And 8.
M-8. It's on 142, date stamp, if you look at those numbers at the bottom. In the middle. Okay. Yes.
Okay.
Are you there?
Yes, sir.
Okay, is this a copy, a true and correct copy of the bill you provided to him?
Yes,
Okay, and did you also provide photographs of the children in the orthodontic chair?
I did. Yeah,
Why did you do
I was
that?
pretty proud because I had said, this is our third one, we're putting through braces.
How much of his half are you owed?
How much of this half
You're asking for half of the insured that was not insured.
of the dental bill?
Yes,
I don't have it in front of me.
do you have a total on the dental bill you're looking at?
This right here in front of me.
Yes, what's the total?
$3,214.01.
And you're asking for one half of that, is that correct?
Yes, sir.
And in your summary request of relief, you had said that was 1,607.08, is that correct? Okay, are you asking for attorney's fees?
Yes,
Are you asking the attorney's fees that the court awards be ordered as child support?
yes,
Are you asking that they be included and withheld? Are you asking for withholding orders on all arrearages the court finds?
yes.
Have you agreed to pay us $4.95 an hour, $2.95 an hour for our time?
Yes,
Okay, have you agreed to reimburse us for our costs?
yes,
You understand that we think that your fees in the exhibit that was, you've seen the exhibit that we provided the court for attorney's fees, correct?
correct.
Okay, you understand that your fees are more in a $20,000 range? You understand that?
I understand.
If they-
Objection leading.
Sustained on leave.
Okay, well, what does the exhibit show that my fees are at?
Which is what number are we at here?
This is
M9.
M9, just look, M10. Just look at the second page, see the total.
We are at 21,266.40.
And you're asking for how much today?
I am asking for 75.
Are you asked, okay. In my opening statement, I spoke on behalf of you, and I made sure you were in agreement with something close 15,000.
15,000.
Okay. So is that, you're only asking for 15,000 today?
Of the 21, yes,
And then be awarded as child support and it will be withheld in addition to the others, correct?
correct,
Are you asking will he be found in contempt?
yes,
Okay, and was he able to work and earn money?
yes,
Okay. Has he made any attempt to pay any of the attorney's fees that you previously received that he's supposed to be paid?
no, he is not,
Okay, has he made any attempt since you served him at this on the uninsured?
nothing.
Okay, have you tried to text him about it?
In the very beginning, yes, but.
That's witness.
Okay,
Ma'am,
Yes,
so when you said you didn't receive $2,900, you didn't receive it from the OVERPAID, correct?
I did not receive it at all.
Okay, well, my question is, when you were paid your child support obligation, you were paid by the Office of the Attorney General State Disbursement, correct?
The disbursement unit, yes,
Okay, now, in your M Exhibit 3, this M Exhibit 3, this is base stamp number 68.
okay,
I have limited time, so I
Yes.
apologize for going fast, I just want to make sure.
okay,
Go to page 68, and this is M Exhibit 3, this is your base stamp number 68, that'll be fine, it's page 10 to 20.
okay. Page 68,
It's the base stamp 68, the date of the page of the order of entry is 10 to 23. I can approach you if this is,
yeah.
okay, here, may I approach on it, just to
Yes.
keep this up.
What page are you looking at? Exhibit,
M3, right here, so 68 total of that stat. Right here, and we can just look at it, this is okay, so.
Yes,
that's
that's
what I. He's ordered to pay all child support payments through the OAG's office, you see that?
yes,
So Mr. Walker's obligation is to pay the OAG. Correct?
yes,
In fact, he has this orders him to not pay it, he doesn't get any credit for any payments not in prescribed in this order, correct?
for the child support,
And cash credit, all child support, right?
for the child support is what I'm understanding.
Okay. So he has to pay the state, he has to pay the state first, that's his obligation, correct?
Right.
He doesn't pay you directly, he pays the OAG, correct?
For the child support,
Okay. Now, ma'am, you're in, you said an M8, this is an invoice for your child's bills, correct?
for her dental,
Okay, this isn't a text message to Mr. Walker saying, here's your bill, correct?
which hasn't been admitted.
Just let me again, it's not
Yes,
that. This isn't a letter you sent to him. Here's the bill, correct?
that's the bill, yes,
Yeah, but there's no letter or any evidence that this was transmitted from this exhibit to Mr. Walker, correct?
questionable.
Okay, now you testified that you gave it to him, but you haven't shown any proof of that beyond your testimony, correct?
Correct.
Okay. Okay, he was awarded to give you a cash medical payment going back to 2021 at the time of your divorce, correct?
Correct,
Okay, now you see exhibit R5 in front of you, that's his payment record.
yes,
You see that going back to 2021, they were assessing a cash medical support obligation against him. You see that?
yes,
Okay. And they're collecting some money from him. You see that?
yes,
And they are assessing it against his medical support obligation, correct?
correct,
So this record tracks all of the cash medical support payments they received from Mr. Walker, correct?
Correct.
Okay. And it also tracks all of the child support obligations, correct? Okay, now. At the bottom. You contend that he actually owed you. $24,124, right? $1,000 more than this child support obligation assessed, correct? All right, but he actually paid, if you look at the total amount that he's got the credit for paying. He actually paid $25,343, correct?
John, I object to that, it's in that he's using total paying the medical support, not the child support. Monthly child support portion of that,
Oh, you're saying he's combining the child support and medical?
with the cash medical, that's not applicable.
I'll be trying to make it clear what I'm doing.
Okay, go ahead.
So you see that column that says, hey, you owe us $22,338 for child.
Slow down, slow
I
down.
apologize.
So you see that column?
See the column that says you owe $22,338.24.
where it says amount applied.
Amount due on child support, you see that, right?
Yes,
Now, your contention is that this should actually be $1,000 high, correct?
correct,
Right? And you also see that it assesses, you said 2,900, they said, hey, he owed $3,000 in medical support, you see that? And it
yes,
said that he paid $3,000 in medical support right next to it, you see that?
see, 3,000,
Okay, now what the OAG said is, the total amount that he owed you according to us was $25,343, you see that?
yes,
Now, what they also said is he actually paid more than $1,000 above overage pay, you see that?
yes,
So what the OAG says, we collected more than $1,000 extra from him compared to what we think he owed, you see that?
yes,
And what you're sitting here in court is, actually, he owed me $1,000 more, correct? And in fact, this actually proved that he paid the OAG $1,000 more, correct? Thank you. Pass the ways.
Doesn't show that he paid $1,000 more on the child support, right? The child support alone,
the child support,
okay, so.
Counsel,
you're got-
you ran out of time. Anything further from Ms. Williams? Go ahead.
So it has, may I approach the witness so I can point this out?
Yes,
Okay. So on the last page. Amount applied, the amount that he paid, 22,000. And then 3,000, correct? For the cash medicals, but it says the total amount that he paid was $25,344.38 that they applied against your medical support. And your transaction, correct?
correct,
And then on top of that, there was an extra $1,000 sitting in that account, correct?
correct,
Overages. So the only way they received that was because he had sent them more than $1,000, what they thought was extra, correct?
what they got,
So if this number was the correct number according to you, this child support amount was actually the $1,000 higher. This money that he sent to the money would have covered.
Objection, Your Honor, that doesn't accurately reflect the testimony.
I think it does.
Your Honor, it does not. We corrected it to where it was 1,000 underpaid, not overpaid.
Your Honor,
It's not accurate.
look at the argument. This
hold
is
on one
what-
second. What was the objection?
I'm objecting that it's not accurate. She's already stated her testimony. It's inaccurate as to what she said. You said they overpaid the 1,000.
So you're objecting to mischaracterization of
Yeah,
her
that's
testimony?
exactly.
Okay, sustain, rephrase.
According to you, the OAG number that he owed you in child support should be $1,000 high, correct?
correct,
And according to that document, he paid more than $1,000 than what the OAG mistakenly thought that he owed.
I object, Your Honor, because it's combining the cash medical support with the child support.
And then says $1,000 more.
They didn't say that he paid more, 1,000 too much in child support. They're saying the combination of cash medical and child is what they're alleging.
Your Honor.
I get it.
Okay.
You get
Or
what it
yes,
shows?
yes.
Yeah.
Thank you, Your Honor. I think it's clear that. I'll pass the witness.
Okay, Attorney Huey is out of time. Ma'am, you may return to your seat. Any objection to him testifying to attorney's fees?
I believe we have his exhibit.
Yeah.
I'll circulate it to his exhibit.
Okay.
Perfect.
I don't want to.
Thank you. You may call your first witness.
I call my client, Mr. Walker, and I get it.
Yes, sure. You have 3 minutes and 49 seconds left.
Mr. Walker, did you ever receive a copy of this bill from your ex-wife?
I don't recall ever receiving a copy of anything.
Okay, now, so the first time you saw this was when?
When I was first served in April.
Of April of this year?
I believe so.
Now, under your order, your agreed final parents order, do you get 120 days from the date that you receive an actual bill? Not a text saying I had service, but an actual bill. Is that what your order says?
Correct.
If you get the bill more than 30 days after service, correct?
Yes.
And you received it in April of 26?
Yes.
All right, and the last service was performed, or the last payment was in October of 2024, correct?
I believe so.
So more than 30 days of the service.
Yeah.
So it's due, according to your order, on August 22nd, 2026,
I believe so.
and you intend to pay it? All right, but you're not currently in arrears, because you get 120 days to pay.
Yes.
Okay, now, did your son drop out of high school?
We did.
Okay, and was he, after you dropped out, was he continuously enrolled in a GED program?
I believe it was sometime after the month.
All right, before you even enrolled.
Yes.
So your child support did correctly reduce, correct?
Yes.
Now, on top of that, before 20, was there any period of
Objection,
What's your objection?
leading, and
Sustained, don't leave.
Alright, what was supposed to happen if your son dropped out of high school and wasn't enrolled in a GED program?
Supposed to, as far as I know, his part of the child support was stopped.
And it would have reduced?
Yes.
Okay, now, in addition to that, was there a period of time when your daughter, the other person on the chart, there's a period of time that she did with you?
That is correct.
What period of time was that?
She dropped off last year, middle of May.
So 2025 or maybe
2025.
objection relevance, Judge.
Counsel, what's the relevance?
Well, Your Honor, my point is that they want to say there's a mistake. We can also say, well, there's a mistake, because the child, a minor age child lived with him, in which case you shouldn't have had a child support obligation either.
Sustain. You have 2 minutes left.
May I approach the witness, Your Honor?
Yes.
I'm gonna show you page 20 of and exhibit 3. This is your agreed, this is the agreed final order in the modification orders.
Right.
Is this the amount where you're ordered to pay attorney's fees? Okay, does this say that this is a child support obligation?
No.
This is just a debt.
Yes.
As per the terms of the order, this is just a debt.
Yes.
And you haven't paid it, correct?
No.
And you acknowledge that you haven't paid it.
That is correct.
Okay, so you understand that you still owe this money,
Yes.
and you don't have a problem with it being found that you owe this money, correct?
That's correct.
Alright. But you just haven't had the ability to pay it?
I didn't know that it wasn't coming out when I was paying the child support.
So it's a mistake.
Yes.
Okay. And this doesn't say where you're supposed to pay it from, correct? It doesn't have a specific source?
No.
Okay. And it's not. Your Honor, we asked you to take judicial note of the file and return a service on the motion to serve.
The court takes judicial notice of all contents of the court's file.
Your Honor, I'll pass the witness and reserve my time for close.
Okay, you may go ahead and close.
Your Honor, the undisputed evidence in front of him is that he paid a total of $25,000 plus an additional $1,000 in overages. That's exhibit R5. Exhibit R5. What Mr. Huey is doing is trying to confuse the issue. What he is saying to you is that child support obligation should be $1,000 higher because it shouldn't have been reduced when it was reduced. That's his argument. Even if he's correct, and he says that number that is current on that document, $23,000, that should be $24,000 or $22,000 on your document.
Did you say 22 or 23?
It's $22,000 on your document. Even if he's correct and he's right that the amount should have been reduced, What that means is,
Counsel, you're out of time. You're out of time. The child, your child, sir, your child, you say dropped out of school in May of 2025?
Yep.
All right. And just so the court is clear, the obligation reduced July 1st of 2024. So what I'm looking at is the amount due that's been due since 2021 was $550. $550.
Your Honor,
I'm on page 10, sorry.
the child support obligation for him actually started in 2022. So that begins on page 5.
April 15th. 2022.
Yes, April 15, 2022 at $550, okay?
Oh, yeah.
And then if you turn to page 10, the amount reduces July 1st of 2024. Is that when the oldest child emancipates?
In July of 20
Technically, he left, he started his senior year
Right?
in August. And he enrolled earlier part of August and somewhere
Of
within
24?
25.
No, I'm specifically referring to 24.
Your Honor, the child would.
Oh, no, he went all the way to 25.
Okay, so what I'm saying is the amount reduced on July 1st of 2024.
Absolutely.
Do you see what I'm saying?
I see what you're saying, but again, Your Honor, based on the math of his own math. But the OAG is saying, this is what we assessed against you. And when it says what you assessed against you, that's the bottom number.
That is why we think it's $1,000.
That's right. Like, there's not a dispute here. There's not a dispute on what, so the OAG says we assessed $22,000, 338.
Right.
Mr. Huey is saying that number should be $1,000 high. That's what Mr. Huey has presented today as evidence. That
91.
It seemed in
Your Honor, that's my point. He's saying that 20.
July 1st, 2024. So somewhere the Attorney General received information that the 550 amount should have been reduced. And if that were the case, it happened prematurely,
But even if that did in fact happen prematurely,
right?
it would have only been 10 months because the child later subsequently turned 18 and dropped out and wasn't enrolled in GD program.
Correct.
The difference is $100. So it's their number.
Well,
And that's my point, Your Honor.
well, we're going to allow the Attorney General to clear this up because I'm not going to fight either of you on the Attorney General's pay record. This is their record.
Well, but again, Your Honor, he's saying you're $1,000 short. And what the OAG pay record, which does track his payment, says he paid more than $1,000 extra. So if he's right and the OAG corrects the number and says it's $1,000 higher, he's not in arrears because his overage
Covers it. I
From a
agree.
contempt standpoint,
There wouldn't be any contempt.
so
There wouldn't be any contempt. According to what I'm looking at right now, there is no contempt. But that's the reason why the Attorney General needs to come and correct it because he still may not be in contempt even after it's corrected.
Right.
Because according to this pay record, he's over.
exactly, Your Honor, and that would kind of, so even if that was the case, and then they misdistributed the money, that's not contempt, and it's not.
And it wouldn't be-
Not be appropriate at that point.
And it wouldn't be his fault because of the failure of the Attorney General to distribute. Because he's only ordered to send the money in through the state disbursement unit.
Unless his employer is listening to what he's saying and they're withholding those amounts.
That's
And hold on, and even if that were the case, I do not have that in evidence in front of me that is what's
I got it.
occurring. So his employer is saying that,
It's one of those witnesses.
Your Honor.
Supervisor.
For the record, just so you understand, context of that incident, is that the OAG continued to withhold money after the obligation in November. They had rule of agreement, this page in the records, saying he doesn't owe any more child support.
As of 11.
As of November 2025.
Yes.
right, and they
The OAG
kept
took
withholding.
money. This record stops in 2025. This record is not relevant past that date. I'm
Mhm.
sure you know. That the OAG did also continue to take money past 2025. As well, that they also refunded a different amount. So like you look, we have a copy of the check. That's why they sent him even more money than the 1,100 that they owed him because they continued to collect. So you're in a point that's, well, he told me to stop taking it out.
That interesting question. How much was the check?
Little
Yeah, because.
What did you do with it? Into your account?
Yeah.
Okay. Yeah, I need the OAG.
Thing
Yeah.
is,
But
she's
for who
out,
you funding?
she's out.
Yeah.
Medical support, she has to do this.
Your Honor,
I-
evidence in front of, what they're asking for in relief today, it's set today.
Well, I already said today I couldn't, he couldn't be in contempt based on this. However,
Even if you already corrected it, even if they said, actually, you did owe $1,000 when we messed up the timing. What's demonstrated on his payment account is that he paid the extra $1,000.
we're saying the same thing. I don't disagree with you. I want for record purposes, I want it to be correct. I want it to be correct because if anything were to come up later in the future, I don't want either of them, her to think she could bring him to court, and I don't want him to think that he would be held in contempt.
Ask Mr. Watt, I would imagine that if you want to say, well, maybe you owed an extra $1,000 and that $1,000 that was sent to you should go to her. I'm willing to bet he would agree, I'll send her $1,000. In which case, but like, no return.
We got uninsured medical and we got.
Well, the uninsured
Well, the uninsured, that's not right yet, because if the first time, she doesn't have anything in front of me in evidence that shows she actually put him on notice of the bill, and the order specifically says that he has to have a copy of the bill. And if the first time, according to his testimony, that he received the bill in April when he was served, is not right until next month, so I can't hold him in contempt. And your client didn't put anything in testimony in
She said it.
she said that, but you all put
She's-
documents,
She's got text and piecemeal.
But not in
right? No, it's not in evidence, counsel. So in front of the court right now, and I am the trier of fact to test the veracity of their testimony, and you're asking me to place someone in contempt. I need evidence beyond word of mouth that is what's occurred in order to hold someone in contempt. But even beyond that, contempt is off the table with that because it's not right.
And Your Honor, my client.
Unless he can show something, or your client can show something, or that's already in evidence where she actually sent him the bill, not a text message. It specifically says a bill, because everybody would be in contempt if that were the threshold.
Client had this hangover since December. You know, and like when we started in April, he incurs expenses to keep this matter open. Based on the evidence presented to you today. Like I said, I think my client.
Let me ask him,
Would
sir,
you-
that $1,200 that is saying you're over, will you agree to give that to her based on what you've heard today, right? Based on what you've heard today and what I said about the discrepancy in the pay record on the child support portion, would you be in agreement to give her that $1,000?
That should be your ruling, and that should be the end of this case.
We have other stuff involved too, though.
Well, Your Honor,
Cash
Like-
medical.
Well,
Who gets cash medical? It never shows.
The cash medical, there is nothing in front of me that says that he owes cash medical.
Oh, yeah, yes, I have that.
Which part?
It's the 2,900.
it's in the record.
This?
It's in, yes.
I don't see anything for a cash medical. It shows on at the end of the page, on page 14, it says medical support amount due $3,005.69. Amount applied $3,005.69. Balance is $0. That's all I have in front of me for cash medical. And the attorney's fees, I mean, I wouldn't award attorney's fees in that amount anyway, because that is excessive on an enforcement, and he's not in contempt. And what I can do is the $3,038.78, and there were prior ordered attorney's fees, I can make that a judgment.
Yes, and we would stipulate that. That's the question. And that's the
Yeah.
relief.
And that's all the court is able to do today. But I do want this cleared up, because this is going to cause problems in the future.
If it's saying he underpaid by 1,000, he'll agree to pay the 1,000. You can enter an order today saying, we can enter an order saying, I find, based on the stipulations of the parties, that the OAG assessed $1,000, did not assess properly, the child support actually owed an additional $1,000.
And see that I have a problem with that.
The OAG won't listen to
language.
you, they won't listen to me, and just,
But here's my problem, Judge. He's known about it since the day we filed the motion that these numbers weren't right.
that's not true.
Well,
That's not true.
hold on.
The OAG number saying he's paid everything.
And here's the deal. this is the OAG's payment record. That's all he is responsible for knowing. And that's all I can require of him, even under an order. He's on notice of what his court order says. And that's the only thing that the court can require of him. And if there's a payment record showing that he doesn't owe anything, it's not proper for the court to find that he's been on notice of it. I don't think that's fair. So, what, if you all would draft an order according to what those stipulations are, that would be great. In the meantime, I am going to reach out to the Attorney General's office because I believe this payment record needs to be clear for the both of them. And
Attorney fees today, Judge?
no,
Because he hadn't paid his judgment, but you're.
I put the judgment on there.
Yeah.
I cannot order him, find him to pay any attorney's fees when I'm not finding him in contempt. Okay, if there,
Are you gonna issue a ruling or saying?
that's it. Now, what you all can do is get a copy of an excerpt of this transcript.
I'll prepare a ruling, but I think I understand the ruling. I'll certainly run it by Mr. Huey and if he wants us for an entry or if he just wants to submit it. I mean,
Just email it to circulate it to Attorney Huey and then email it to my coordinator. It'll get to me a lot faster. And sir, you just so we're clear, your that's $1,607.08 for your portion of the uninsured the unreimbursed that needs to go to her by August 22nd. Okay, cashier's check or money order. Make it payable to her.
Yeah, so I have the number for the unreimbursed reinsurance. That's half of that bill is $1,607 unpaid.
And 1 penny.
And one penny, I don't know for my client, you don't get.
Okay,
That's due on August 22nd. And then I think what my client was stipulated through, I'll put in the order, is that he owes $1,122.61.
No, that's not right. You keep saying that.
Well, your number was less than, your number was 1,000.
Maybe.
Okay,
it's $1,091.76.
I'm just making that to August 22nd. She said that's a little less than 30 days to pay that as well.
Is that fine? August 22nd. Okay. So, sir, is that even feasible to pay both of those by that date? Okay, so if that's the case, then the total that you will be paying is $2,698.77. Okay,
I'll prepare over this.
thank you. Thank you all. You're dismissed.